if that form contains any evidence which is unlawful, unfair, illegal, unlawful, or it is acquired, then this court can't admit it. That's what the law says. So, Mr. Baloyi.
I can assure Advocate Minisi that if, and we can cut through to the chase on this matter, if there's anything he thinks should have been omitted, he can bring it to our attention. But we have taken every care to ensure that such utterances don't appear on the form.
No, but he says you must do it jointly with him and his colleagues. How you structure your case, in other words, you must discuss it with them. That's how I understand.
There's no such duty, man. That we must discuss. There's no such duty that we must discuss that with the state. They've been furnished with the copies, and as we've indicated, if there's anything that they think, and we will not place, my lord, anything that is admissible at this stage. We are aware of the issues that is raised. We've taken every care to ensure that such utterances don't appear on the pro forma, but if we've missed anything, he's more than at liberty, my lord, to draw our attention to it. But at this stage, my lord, as far as this witness is concerned, that we are just about to call, that issue doesn't arise at all.
No, but he says, in respect of his client.
But he just said his client didn't make any statement.
Well, I don't know. That's the point. But he says if his client, if he hasn't made a statement, but if his client has answered in a manner which incriminates him, then he's got to be advised accordingly, so that should be redacted.
And it's not even, those statements are not yet before court, my lord. I think he's just referring to the pro formas that have just been handed up.
Yes, the statement. I won't see the statement until this court decides. What does Section 217 say?
Yes. Well,
let's quote it. Let's quote it so that people know what the law is about. 217. Let's read it. There are three requirements, as I recall. It must be made freely and voluntarily.
Without undue influence.
Yeah, let's read it. Let's read it.
Okay. Well, Section 217 states as follows, my lord. And it regulates confessions. Admissibility of confession by accused. Evidence of any confession made by any person in relation to the commission of any offense shall, if such confession is proved to have been freely and voluntarily made. So the first prerequisite is that the confession must be freely and voluntarily made, and that is the exercise, my lord, that we are now busy with. And secondly, it must be made voluntarily by such a person in his sound and sober senses. So the second prerequisite is that the person must be in their sound and sober senses. And thirdly, without having been unduly influenced thereto. So those are the three prerequisites, my lord, that we currently engage with, my lord, to determine the admissibility of the statement before the statement itself can be admissible.
Yes, fine. That's what the law says.
Yes.
And these courts can only make that finding after having heard all the arguments, all the evidence first, and all the arguments, and all the submissions by both the state and council. And Mr. Minisi, you have the right at any stage in that pro forma form where you believe that your client, even though you say your client has not made a statement, where you believe that your client has given an answer which incriminates himself, or if according to your own knowledge and interpretation of the law, that answer will influence this court in finding in favor of the state. And this court can tell you, I only find in favor of the law. Not the state Now the defense, I am just a servant of the law. If the law allows it, I'm obliged to do it. If the law doesn't allow it, doesn't matter. I won't allow it. Okay?
Yes, that is appreciated, but this only does not. This does not only go to accused number 3. It goes to everybody.
All of them, yeah.
Yes. 1, 2, 3, 4,
5,
5.
yes.
The fact that I'm saying accused number 3 did not necessarily make a statement, that does not also go, that shouldn't go to accused number 1 and 2. The court has just indicated the exception of what the court just said.
No. Mr. Rappel also says his client made a statement. I don't know. He says his client made a statement. And his client was done this and that and that. And you are saying your client never made a statement. Mr. Ngomalo says his client never made a statement, and correspondingly, accused number 5, counsel says his client never made a statement.
What I'm saying, my lord,
Yeah.
is, irrespective of the fact that my client made a statement or not, the state says accused number 1 and 2, pointing out the confessions. That does not exclude me from participating.
No, it doesn't, of course.
Yes.
It doesn't.
That is the reason why then I'm saying, my lord, that any documents that pertains to them as well,
Yes.
it needs to be conversed with us before it can be handed over to the court. The court cannot hand documents to the court before those documents are conversed with us.
But you see
That
what?
is my concern.
Yeah, but you see what this gentleman is saying, Mr. Baloyi. He says you have that pro forma form. That's what he says. It's not me.
I don't have that pro forma form, which part of which has been deleted before it was handed over to the court.
Yes, Mr. Baloyi.
Honored, we really need to save court time here. We've made it clear that as far as the first witness is concerned, that issue doesn't arise, and if Advocate Minisi can point us to a specific
Why don't you give
point-
Advocate Minisi the redacted part? You say you have redacted it.
Yes.
Just give him the document, which is you call the pro forma.
And it should not only be myself alone.
No, please, Mr. Minister, I'm addressing your concerns. The other gentlemen can speak for themselves.
And
Mr. Ngumalo knows what to say.
that's Exhibit HH, my lord, on page.
But give him the redacted part, your redacted part.
Yes.
That
Yes.
pro forma.
Yes. I just
Because he says he doesn't have that one
yes.
in his possession.
Yes.
Actually, what you should do, give it to each and every council. Rose, where's my register?
But yes,
Can you
but-
make copies of before we start? Can you make copies of that? Can you make copies of that?
Yes, I understand, but my suggestion, my lord, is that we draw, because they're still going to need this information. If they expunge it from their copies, they'll be without that information. If
No.
if
You give him what you give him what you have.
yes,
So it's what you have, which you give to them, and what you had already given them.
Yes.
Is that not so?
yes,
Just make copies, so that nobody must accuse this judge of conducting an unfair trial.
yes. Perhaps if it's acceptable to Advocate Minisi and to the court, we can draw his attention to the parts that have been expunged, and we
I'm
can
going to
just-
adjourn. Draw, as you say, you're going to discuss it with him. But this court says you must make copies for that document which you intend using as pro formas,
Yes.
okay? Which you have redacted. All right. I'll give you 15 minutes.
All right.